My name is Graham Walker, and I am a partner in BLG's Vancouver office. I'd like to welcome you all to BLG's legal update a year into COVID. And what a year. What a 15-month period it's been. Lawyers from across BLG have continued to provide support to our clients across industries and sectors to respond to the ongoing and evolving COVID crisis. Today, we've brought together lawyers from all of our offices and practices to speak about what we've seen and what we see coming down the pipeline as the situation continues to evolve and hopefully improve as it appears to be doing. Before we launch into the presentations, I want to say that despite the challenges of virtual presentations before larger audiences, we do encourage questions from all of our clients in attendance for our presenters. And I would ask that if you have a question, please use the chat box function on the bottom right-hand side of most screens to enter your question. And if you can, identify the speaker you would like to address the question. There is also an option to choose all panelists, and please do that if that's easier. We will do our best, time permitting, to answer all questions during the presentations or at the end of the seminar. Now let's begin the legal update. Ava Karyuska is a commercial litigator in our Toronto office who's been at the forefront of advising on the impact of the various emergency management legislation proclaimed across Canada and how those laws impact your businesses. Ava, over to you.
Thank you, Graham, and welcome everyone. So I'll speak about the emergency legislation that the various levels of government have relied upon to manage the pandemic. And all levels of government, the federal, provincial, and the municipal, have relied upon whether it's emergency legislation or other legislation to address the public health risk of COVID-19. So I'll go kind of by level of government, federal, provincial, and then municipal. So at the federally, the federal government chose not to invoke the Emergencies Act. The government decided that so long as the provinces were managing the pandemic within their spheres of jurisdiction, that it would not invoke the Emergencies Act. But the federal government did take care of issues with regards to its own sphere of jurisdiction, which is with respect to the border. And for that, the federal government has relied on both the Quarantine Act and the Aeronautics Act. And so the Quarantine Act is what has been governing the closure of the border of the United States, the requirements to quarantine for 14 days, the requirements if you travel by air to stay in a hotel for several days and to be tested, and the Aeronautics Act to present a negative test before you board a plane. In addition, the federal government has enacted a panoply of fiscal legislation to help support businesses and businesses that have been shut down during the pandemic. And so it has provided more of a fiscal response or fiscal support to the pandemic. And then moving on to the provincial governments. The provincial governments have really used two tools in their legislative toolbox to address the pandemic. The first has been emergency legislation and enacting emergency orders. And the second has been public health legislation. Each province has a public health act that it has relied upon. And so in both cases, and this has varied from province to province, but all provinces and territories at some point in the last year have been in a state of emergency or a state of a public health emergency, one or the other or both. Often it has been cabinet who has enacted orders for the shutdown or lockdown of businesses, enacting capacity limits, stay-at-home orders, curfews. Those have all been done often by cabinet under emergency legislation. And then public health measures have also taken place under public health legislation, sometimes in parallel, sometimes on a more local level to be stricter than what the province has enacted. And there have been challenges to some of these orders. And most of the challenges throughout Canada have not been successful. The courts have overall deferred to the government in terms of how the government has decided to address the risks of the pandemic. And so the courts have set a relatively high bar for any challenges to government orders. And the bar is really that so long as the orders are consistent with the objectives of the legislation, and the objectives of the legislation are to address the pandemic, the government does not always need to lead evidence that the orders are going to be effective. That's for cabinet. On the public health side, there have also been challenges to the orders of some public health officials, and those have, for the most part, also been upheld. And that's also been on the basis that as long as public health officials have demonstrated that there's a reasonable and necessary basis for the orders, the governments have deferred to that expertise and have also relied on the precautionary principle. And then lastly, there have been much more local orders. So both municipalities and local medical officers of health, especially in Ontario, have relied upon their own powers to make orders specific to their jurisdictions. And sometimes that has meant that those orders have been more strict or more restrictive than the provincial orders. And that has been done to address kind of a particularly acute situation in their jurisdiction. And so that is the overall framework, the law that we today live in. And now we have seen recently most governments proposing what are going to be the reopening plans across Canada that are mostly set against vaccination thresholds and other public health measures. So that's all of it, Graham, very quickly.
Thanks very much, Ava. Yeah, we have a lot to get through today, so I do appreciate your timeliness. And certainly our experience in British Columbia has been that any attack of any provincial or local attempt to reopen has not gone well for the entity that has tried to confront the legislation in place. So next, Heather Pessione of our commercial litigation group and Cindy Clark of our health law group have both been instrumental in supporting healthcare clients as they support vaccine rollout in Ontario. Heather and Cindy are here to tell us what they've learned and what they can predict based on the always shifting landscape. Over to you, Heather and Cindy.
Great. Thank you so much, Graham, and welcome everyone. Delighted to have you with us. So we just thought we would give a brief overview with a focus really in Ontario, although we do have some national information. I think delightfully, we're all happy to see that the vaccine supply is finally here in much more significant volume, so that's terrific. In Ontario, what has happened is the system is governed by something that's called the COVAX, and you've heard that name in the news. That's also the name of the international organization which is gathering vaccines and looking at worldwide vaccination and vaccine availability. In Ontario, it also happens to be the name of the database that the government has developed and organized for the purpose of tracking COVID-19 vaccine administration. So one of the important things to know is that regardless of where one gets a vaccine, whether it's in a hospital, a pharmacy, a pop-up clinic, or any of these employer-based, which we're just starting to see clinics arising, all of them at some point engage with the provincial system, and that will be the main repository. So I think there have been challenges as we've been going through and getting this set up, and we've been involved from the very outset when the first clinics were developed and the pilot programs were running. But this program has been in place since that time, and I think it will help in certainly as we move into the second dose administration, which we'll talk about in a minute, to have one central place in which all information is gathered. Of course, that's not necessarily the same system into which one signs, so the onboarding and when you go to make your appointment can be a different system than the actual one where information about your vaccine administration is stored, but again, that's a minor complication in the scheme of things. The federal government is controlling generally the vaccine supply. As you've seen, we've seen Trudeau and his team manage that piece. They allocate it out to the provinces, and then within the province, each province can determine how to set priorities in terms of who is eligible for vaccine. And there are a number of governmental guidance documents which speak to that, and agreements which govern, which Heather's going to get into in a moment. So it is in fact legally based in terms of how priorities are given and the responsibility of any organization that has vaccine supply to administer it in compliance with current guidelines, which we've also seen change regularly and routinely. So keeping up to date with what's on and what's not on and who's on first is certainly been a challenge and basically a daily monitoring event. In Ontario, there is an order from the Chief Medical Officer of Health, and this permits nurses to administer without a medical order. So we have a combination of mechanisms by which vaccines are delivered, but in the main, we have nurses administering predominantly across the province pursuant to that order from the Chief Medical Officer of Health. Otherwise, there are some local orders in place. We just heard Eva speak about local medical officers invoking certain orders, and then in a particular, physicians also have the authority to delegate out responsibilities, and this would be one of the things which they could delegate. But we think that the prime source, and it's been one benefit that this has been a centrally focused conversation, has been to secure all nurses with properly licensed having the ability to administer vaccine without a physician's order. So Heather, over to you with a bit more information about the COVAX agreements.
Thanks, Cindy. And so the province's vaccine rollout on Ontario, like Cindy mentioned, it's largely been through agreements, so with hospitals, public health providers, and others, and with that prioritization policy piece set by the province. Starting in December 2020, a small number of hospitals across the province were asked to start piloting vaccine distribution. And at that point, the province had access just to the Pfizer vaccine, which had deep freeze requirements, which were best accommodated by large hospitals. These hospitals entered into agreements with the province covering the facility, conditions for administration, so following that prioritization from the province, and the facility's use of that COVAX system that Cindy outlined. At that time, the hospitals ran healthcare worker and long-term care clinics, because those were the priority populations at that time. Around February of this year, there was a shift in government policy. And from that point on, the vaccine has flowed from the province to local public health units for distribution. Moderna and AstraZeneca were rolled out over this time frame, and they have less onerous storage requirements. So this opened up new possibilities for vaccine delivery with pharmacies and primary care employers and others. So public health units now distribute to all of those different types of providers for delivery according to provincial and now also local guidance. There's some flexibility at the local level to set some of the priorities. Most bookings now are made through the provincial system. Again, that's the COVAX system, that's the central repository, but some units and providers are still using those separate booking tools. So now, instead of agreements between the province and hospitals directly, there are agreements between the province and public health, and then separate agreements between public health and those various providers. Those agreements are all different, and they can cover additional things now too, like deployment of staff, for example, amongst organizations to support vaccination efforts. So multiple organizations that we support at BLG have been coming together to support the vaccine effort at what has been obviously a very difficult time for healthcare for our clients. In particular, hospitals have been assisting not only with this vaccine distribution piece, but with COVID assessment, supporting long-term care, increased strain, ramping down emergent procedures, taking on help from different providers than they're used to in different provinces, increased transfers, obviously the list goes on. And as Cindy mentioned, provincial and local prioritization and distribution has been evolving rapidly as we receive more vaccine and as the National Advisory Committee on Immunization and other policy has shifted. So for example, as you probably know, lots of changes over time in terms of priority groups, priority geography, use of the different vaccines for different purposes, and second dose intervals, which is really top of mind right now. I'll turn it back to Cindy to talk about from her experience about how providers have managed this.
Thank you, Heather. I would say it has been an extraordinary privilege to have the opportunity to work with so many organizations as they come together throughout COVID, but Heather and I particularly in vaccine support, because it really is in ways I don't think we've seen before in Ontario. Collaborations across different kinds of organizations, some offering space, others offering people, others offering equipment and tools. So just thinking about all the logistics that go into running a successful clinic, and of course wanting to be able to maximize the speed at which doses are administered in a safe and effective way. So that's been really great, and it's been fascinating. And of course, as you can see, it has taken a lot of conversation and understanding between the different organizations as to who is doing what and needing to stay on top of it. So I think we've seen many adapt and roll with things as they come, and I think we will continue to see more of this. Certainly, it is tricky, important to understand the context anytime you get asked about vaccine status, understanding that some information we see comes from the province, but then as it applies locally, it could be that something that's announced in the province, like vaccine available to 12 to 16-year-olds, is a newish development. But in some places, you can't book an appointment for that age group for a couple of weeks. In other places, if you happen to be in a different region, then you might have already had your kids vaccinated. So it really is very context specific and site dependent. But there has been, I think, ongoing collaboration, and really with a view to trying to make sure the rollout is fair, it's equitable, and as you've seen more and more increase, we're always learning, right? So the science is developing, the science impacts the rollout, it impacts prioritization, and now I would say it's all about second dose administration. So what we anticipate is going to come is more and more information about AstraZeneca, when it can be available. At the moment, they're now shortening. There's special permission to allow some to get an early second dose to make sure we take advantage of these AstraZeneca doses that are prior to their expiration date. I think it'll then go back to the regular 12-week suggestion. They're considering whether or not those who had AstraZeneca should have opportunity to get a different vaccine the second go around. So more direction to come, but I think we need to recognize and applaud the efforts that have been made, and I think we can all, my prediction is that the second dose pacing will increase, although I think it's unlikely to be too much shorter than 10 to 12 weeks. My hunch is it'll stay in that zone, but that there will be a major effort to get as many second doses done by the end of August as possible, with a real focus on return to school and quote normalcy as we move through the system. And of course, a whole other conversation about getting our healthcare systems across the country back to the other work that has been put to the side as they've managed through this crisis. So I think that gives Graham an update on vaccines and vaccine administration and what we can expect, at least to the best of our ability, in the next short while.
Well, great. Thanks, Cindy, and thanks, Heather. And as they mentioned, the vaccine rollout in many provinces is now becoming much more robust. And as we see more vaccines becoming available, but lockdowns in some provinces continuing, Rob Weir of our Labour and Employment Group in Toronto is here to talk to us about employee vaccination and layoff issues that many businesses still today continue to struggle with. Rob, over to you.
Thank you, Graham. As you said, since the beginning of the pandemic, our lawyers have been engaged in a variety of issues around employment-related issues and the pandemic. And the most current one, and the one we get asked about a lot, is now mandatory vaccination policies. We get asked the question a lot, but we haven't had many clients implement such policies. And there's a number of reasons why implementation is more difficult than it seems. First, I think every single provincial government, the federal government, has said that they have no intention of legislating mandatory vaccination in any environment. So the politics of mandatory vaccinations are viewed negatively by the politicians. And if you're an employer, it will be viewed negatively by many of your staff. That same politics will play out in your workplace. Second, mandatory vaccination means mandatory collection and disclosure of vaccine information. And Ira will talk more about this later, but on May 19th, 8 days ago, the privacy commissioners across the country, the provincial and the federal privacy commissioners, came out and said that in terms of collecting and storing this private personal health information, they do not intend to be more permissive simply because we're in a COVID atmosphere. In other words, they're going to apply their privacy laws just as rigorously as they ever do. Two primary reasons are there's tremendous legal uncertainty about mandatory vaccination policies. In a unionized environment, we have a lot of cases on mandatory vaccine policies in the context of influenza outbreaks. We have mandatory masking cases in the context of influenza as well. We have no cases about mandatory vaccine policies in the context of COVID. And arbitrators are very reluctant to uphold these policies. Some have been upheld over the years in certain contexts, but arbitrators place a fairly high standard on an employee's right to privacy and their right to bodily integrity. And then in the non-unionized context, employers who implement these policies will have to worry about constructive dismissal claims. So in other words, an employee is working under certain conditions and then is told that they now have to take a mandatory vaccine. Is that employee entitled to treat that as a constructive dismissal? Again, there's legal uncertainty about the answer to that question. Practical issues as well have impacted the implementation of these policies. As Cindy pointed out, we haven't had enough vaccines. Canada has a very, very low rate of second vaccinations, amongst the lowest in the developed world. And how can you have a mandatory vaccination policy if people cannot get the vaccine? That will change as the vaccines roll out. Vaccine hesitancy is another major issue, a major practical issue here. So the Globe and Mail has been tracking over the course of the pandemic and since we've had the vaccines, the rate of vaccine hesitancy across the country. And last week on May 19th, they updated their survey and they estimate that between 8 and 16% of all Canadians are hesitant to get the vaccine. That varies depending on the area of the country you're in. But if you take that and extrapolate that into your workforce, and you assume that 8 to 16% of your employees are reluctant or will refuse to get the vaccine, what do you do with that 8 to 16% of employees in the mandatory vaccination program who refuse? Do you fire them? Do you fire them for cause? Do you place them on an unpaid leave of absence? Do you say, okay, for those who can, you just continue to work from home? So there's a lot of practical issues that are slowing down the rollout of these programs. Most employers are choosing what I call the incentive approach as opposed to the mandatory approach. And this includes providing paid time off to take the vaccine. Some employers are providing cash incentives, extra time off outside of taking the vaccine. As Cindy pointed out, many large employers are now co-sponsoring their own vaccination clinics across the country, and they're using that as part of their health and safety program to encourage employees to get the vaccine. So what will change, what will make us as lawyers more certain that a mandatory vaccination program is defensible? And it's the science. As soon as science can tell us that vaccinations are more effective and necessary, more effective than masking and physical distancing in the workplace, and that's still an open question that epidemiologists are debating, we'll be in a better position to say a mandatory vaccination program is justified. And then as Eva pointed out, different health standards are evolving so that in workplaces, even in Ontario, such as long-term care homes, where I have 85% of my staff vaccinated and 75% of my residents vaccinated, I am subject to lower public health standards. I can have more visitors. I can have less social distancing. I can have lower costs. And when those public health measures apply to your workplace, I think you'll be in a better position to impose mandatory vaccination policies. I believe they're coming. I believe in Canada, as in the US, the first place we'll see these is in post-secondary institutions such as colleges and universities in the fall. who will require their students and their staff to be vaccinated. These policies always have to be read in conjunction with the Human Rights Code, and exceptions have to be made based on religious and medical grounds. I'm going to switch gears entirely and talk about what we were dealing with back at the start of the pandemic, and that is layoffs. So on March 16th, when we all went home, March 16th, 2020, when we all went home, within about a month, I would say the 80 or 90 lawyers in my group collectively assisted in the layoff of about 200 to 300,000 employees across the country. And when it became clear that those layoffs were going to be much longer than we initially feared, the Ontario government and other provincial governments suspended the application of their Employment Standards Act. So as many of you know, once a layoff in Ontario, it's 15 weeks or 35 weeks. Once a layoff exceeds those periods of time, and there's 35 weeks is if I continue benefits and other payments to my employees, an employee is terminated. And therefore, all the costs, all my termination costs, maybe my mass termination costs, kick in at that point. And what the Ontario government did on May 29th is it suspended that outcome. It suspended it until the end of the year, until the end of 2020. And then in late 2020, it suspended it again until July 3rd, 2021, so in just over a month. And it deemed all those people to be on an infectious disease emergency leave. And what that did is it relieved the employers of the obligation to provide statutory severance pay in Ontario and statutory termination pay, at least now until July 3rd, 2021. The question though was, what did that mean for common law constructive dismissal claims? Many commentators and lawyers said, well, that suspension means that also suspends the application of any common law constructive dismissal claims. And that was an open question. But on April 21st, 2021, the Ontario Superior Court of Justice answered that question, and it said no. It said that the amendments to the Employment Standards Act only apply to the Employment Standards Act, and that an employee's common law right to sue for constructive dismissal is not suspended by those amendments. At common law, an employee who is laid off is entitled to sue for constructive dismissal unless their employment agreement or a practice of the employer provides that layoffs can be, an employee can be laid off. I can tell you that 100% of all, 99.5% of all employment contracts did not have layoff provisions in them prior to March 16th, 2020, and 100% of them now do have those provisions, but most people who were laid off back in the early days of the pandemic did not have those provisions. So those employees are all entitled to sue for constructive dismissal. Now, this case I'm referring to did not deal with a number of defenses that were not available in that case because of the facts, or they just weren't argued. So there are still many defenses available to a constructive dismissal claim. One of those is condemnation. I have clients who laid off people back in March of 2020, and those employees are still on layoff today because those businesses have not been allowed to open. And for those employees who've been laid off now for 15 months, if they haven't raised a constructive dismissal claim yet, I think they've condoned the layoff, and they're not entitled to sue for constructive dismissal. And the second main defense that is available is a frustration argument, and that is where a contract is incapable of performance because of an outside force or circumstance. It's said to be frustrated. And in the context of these broad emergency orders that close many businesses or partially close those businesses, the doctrine of frustration will provide, in my view, a very strong defense to common law claims of constructive dismissal. Many employers were required to shut down by government orders. It wasn't their choice. And those employment contracts became impossible to perform because of those orders and because of the pandemic. Graham, those are my two areas, and I'll throw it back to you.
Great, thanks very much, Rob. Very interesting presentation that certainly highlights the extremely challenging issues for employers, giving all the legal uncertainties. Now, we do have some very good questions coming in from our registrants, but I think just in the interest of time, we'll attempt to deal with those at the end of the presentations. So we can't obviously speak about COVID-19 without discussing its impact on the long-term care and nursing home environment. And Barb Walker-Renshaw of our Health Law Group in Toronto has been working with long-term care facilities and hospitals in the province to manage the ever-evolving interaction between the long-term care operators, hospitals, and the provinces. Barb will also share some of the findings of the recently released LTC Commission report in Ontario and consider how it may impact the industry on a national basis. Barb.
Thanks, Graham. I'm really grateful for the opportunity to offer our guests today some observations on the legal issues that we saw arise for the long-term care sector during the pandemic. My comments today focus on Ontario's laws and experience, but the unprecedented challenges faced here by the long-term care sector are similar to those in other provinces. To situate us chronologically, I want us to think back to when Ontario first declared a state of emergency in relation to the COVID pandemic on March 17th, 2020. And by way of context, I want to point out that Ontario has in total 626 long-term care homes that provide residential care to over 78,000 residents. But by mid-April 2020, about 127 long-term care homes were in outbreak, about 20%. Now, fast forward just over a year to May 5th, 2021. Many more homes in Ontario had experienced COVID outbreaks, and some 15,300 long-term care residents had contracted COVID since the beginning of the pandemic. And we all know that sadly, COVID-19 claimed the lives of over 3,700 long-term care residents in Ontario. The reasons why long-term care was so adversely affected by the pandemic are complex and have been subject to review by Ontario's Long-Term Care COVID-19 Commission of Inquiry that was chaired by the Honourable Frank Morocco. The Commission released its final report. Due to the urgency of what was happening in long-term care, the Commission released a couple of interim reports, but its final report was released on time on April 30th, 2021. It's available online if you simply search LTC COVID-19 inquiry and you'll have access to the report. And I can't do justice to it in the 5 minutes or so that I have today, but I really recommend it to those of you who are interested in this sector. What we do know is that from a legal perspective, that as COVID spread through long-term care homes and got into really a crisis situation, acute care hospitals were called on in Ontario to assist long-term care. As this is outside of the normal regulatory framework for public hospitals under the Public Hospitals Act in Ontario, other legal mechanisms had to be called on to facilitate that assistance. Initially, hospitals provided infection prevention and control assessments and recommendations that were often ordered by, not often, but in some cases, ordered by local medical officers of health under the authority of a particular section of the Health Protection and Promotion Act, Section 29.2. I mention it because this section was drafted following the 2003 SARS outbreak in order to give local medical officers of health the power to order hospitals to take action to respond to infectious disease outbreaks. Similar SARS-related amendments to the Health Protection and Promotion Act gave powers to Ontario's Chief Medical Officer of Health to issue directives to various entities, including long-term care homes and retirement homes. These directives were aimed at mitigating and preventing further spread of COVID. It's interesting to look back that the first directive, which we know to be directive number 3, because that's the number that was of the directive that was issued to long-term care homes. It was issued on March 22nd, and the language in it is notably different from what we see today. The language was more suggestive. We suggest, in terms of the measures that were to be taken, in that it recognized that the measures could be implemented where possible. Now, the most recent version, issued May 21st, 2021, sees the use of much more prescriptive and mandatory language as compared to what we saw in the early days. A further legal mechanism that was used to mitigate long-term care home outbreaks in Ontario arises under the Long-Term Care Homes Act, which provides a number of regulations and compliance obligations on long-term care homes. In particular, Section 156 of the Long-Term Care Homes Act allows the Ministry of Long-Term Care to order a home to retain a party of the ministry's choice to manage the home. And this is accomplished via orders and mandatory management agreements. The first such orders and agreements were ratified in late May 2020. All of these experiences and legal mechanisms were reviewed by the Commission of Inquiry, and I think they have the review, as well as our focus in this area, has given rise to a number of what I see as potential implications for the future. First, I see more formal relationships between long-term care homes and acute care hospitals. I think that it's obvious that long-term care homes can benefit from the infection prevention and control expertise that is resident in hospitals. Secondly, I see recognition that the current long-term care residents, as compared to a decade ago, have higher and more complex needs. I think that there will be a shift to viewing long-term care as more akin to what we call complex continuing care in the hospital sector versus the mere provision of, sort of residential care only with access as needed to medical care. Thirdly, I think there's an urgent need to address the chronic staffing shortages and the aging infrastructure in long-term care. When you put that together with the urgent need for more long-term care beds, you remember earlier in my remarks, I commented on the fact that we currently see over 78,000 long-term care residents in Ontario. You have to think about that in comparison to the fact that there are over 38,000 Ontarians waiting for placement in long-term care and an estimated need of even more beds in the future. So what does this mean? I think it means more long-term care builds that are going to be required to address the aging infrastructure and the need for more beds. And finally, you have to kind of consider this into what the Long-Term Care Commission talked about, which was they called for a renewed focus on mission-driven or care-focused long-term care, as opposed to long-term care homes where the primary motive was providing or making profit for shareholders. So query whether that will lead to some private sector, public sector partnerships, as we saw in other areas for building courthouses or hospitals. Those are some of my thoughts for the future. And Graham, I'll turn it back over to you.
Thanks so much, Barb. Dynamic and fast-paced situation, obviously a lot more positive changes to come. So we'll now switch gears a little bit and turn to some insurance issues. Insurers have faced significant pressure as a result of COVID-related claims, and the impact of this on both insurers and insureds is something that lawyers across BLG have provided advice on throughout the past 15 months. Pat Heinsohn of our Calgary office and a lawyer in our insurance and tort law group will tell us about what he has observed across the industry and what changes might be here to stay. Over to you, Pat.
Thanks, Graham. I will be brief in my comments for two reasons. First off, insurance is inherently boring. And secondly, I note that Graham has a piano behind him, and I'm very hopeful that at the end of this session, he might play everybody a tune. So Graham, thumbs up to that. We're seeing typically two issues. You have a scenario where a government authority shuts down an insured's operations, either individually or as a collective. So take, for example, the gymnasium or the restaurant, that sort of thing. And we also see impact with government authorities shutting down borders. So take, for example, the shutdown of the US border, which would drastically impact tourism to Canadian resort communities. And if you happen to operate a VRBO or something along those lines in one of those resort communities, your income is going to be significantly impacted. What the policies tend to be, the issue in terms of the policies tend to focus on business interruption and rental coverage. The insuring grants under both of those types of coverages are relatively similar. So as an example of an insuring grant for rental coverage, you'll see an insurer agreeing to pay the insured the loss of rental income suffered during the indemnification period as a direct result of damage, quote unquote. So when you review your insurance policy, you then go to the definition of damage to see what it says. And damage typically means the direct physical loss or damage to property at the insured's premises from an insured peril. Now, the key to that in the COVID setting is the requirement for direct physical loss of or damage to the property. So for a very clear example of physical loss, one only has to think of a fire that takes place in a premises and the business interruption or rental interruption that would take place as a result of that physical incident in the premises. Now, policies have further terms that either add to or subtract from the scope of the insuring grant. This could be a law school class unto itself, but for the purposes of today, I'll just give a couple of brief examples. One is interruption by civil authority. That tends to be an extension of coverage that is added to a policy. So this extends the insurance for rental income, for example, while access to the premises is prohibited by order of civil authority, but only when such order is given as a direct result of damage to neighboring premises by a peril insured against under the agreement. An example of a clause that subtracts from the insuring grant would be a microorganism exclusion. Now, for example, a typical microorganism exclusion would read, the policy does not insure any loss, damage, claim, cost, expense, or other sum arising out of mold, mildew, fungus, spores, or other microorganism of any type, nature, or description, including any substance whose presence poses an actual or potential threat to human health. I would note as well that some policies also contain communicable disease endorsements. Now, there are a couple of issues that tend to arise as a result of these wordings that are not atypical in insurance policies. And the first one is the presence of COVID-19 spores in premises direct physical damage to those premises? If the answer to that question is no, then the insuring grant is not triggered in the first place, and the analysis typically stops there. In other words, you don't then have to move to what exclusions might be part of the policy. The second issue that we are seeing is COVID-19 a quote-unquote microorganism as defined in the microorganism exclusion that might exist in a policy? So if, for example, the answer to that question is yes, COVID-19 is a microorganism, then even if the policy is triggered in the first place, the insurer could take the position that the exclusion would apply and coverage would be denied based on it. Now, these are really contentious issues in well, globally, frankly. I was going to say North America, but it's a global issue. There are, as it sits currently, 23 class actions in Canada as of May 15, involving claims against insurance providers from anything from restaurants through to recreational properties that are rented out and everything in between. We, as BLG, defend various Lloyd syndicates that have been identified in those in the policies that have been provided in those litigations. The primary class actions are the workman's optometry matter in Ontario, which involves business interruption, and the Watauga Properties class action in Alberta, which involves rental income. So at the end of the day, every insurer has its own policy wordings, and small changes in the wordings can have significant impacts on the coverage that might be afforded under those policies. I would strongly recommend that if you have any questions about the coverages that may be afforded under policies that you maintain, that you contact your insurance broker to ensure that a review is performed of those policies and that you are fully aware of where there might be issues as it relates to these specific problems that COVID presents us. And Graham, I will turn the floor back to you.
Well, thanks very much, Pat. As you know, I find insurance to be of keen interest, as does obviously the plaintiff's bar. And I think that advice that you just provided is well noted. I think we certainly are going to see more class actions to come, no doubt about that. I would also say that Heather also has a piano behind her, and I know that she is a much more accomplished musician than I am. So, stay-at-home orders. Public anxiety and the pressure on the healthcare systems has led to increased activity in virtual care space. A number of organizations are expanding into this space or expanding existing operations into Canada. Anna Marison and Ira Pargi of our Health Law Group will talk to us about the challenges and opportunities associated with the expansion of virtual care across the country. Anna, Ira, podium's yours.
Great. Thank you, Graham. Anna, let's kick things off with what's maybe sort of a basic but important question. Virtual care is a term that gets used a lot. What do we mean when we're referring to virtual care?
Yeah, good question, Ira. And I think it depends a bit on the context. So people go by the term virtual care, also telemedicine, telehealth, and I think a few other terms. And it depends, as I said, on the context. So certain entities, including for some payment purposes, narrowly define what virtual care is and say it's only where care is provided over telephone, live telephone, or video. But for today, we're going to use the broadest term. So for today's short talk, we're going to include all forms of electronic communications, including asynchronous messaging. And I know asynchronous is a term now many of us are using, didn't use a year ago. So we're today talking about everything, synchronous and asynchronous, sharing of photos, email, telephone, and video calls, all of it. And this shift that Graham referenced, this shift to an increasing use of virtual space, is it happening only in healthcare in your experience?
No, I mean, I think what's interesting is we focus on sort of conventional physician and hospital care when we talk about it, but we're also seeing it with other licensed healthcare professionals, you know, psychologists, social workers, psychotherapists offering their services virtually. And we're even seeing it outside of healthcare. So we're seeing a lot of social service agencies pivot to virtual care provision. And of course, as many of us know, somewhat painfully, we're seeing schools make this dramatic leap as well to virtual education, virtual exams, virtual proctoring, all of those sorts of things as well. But, you know, I'm curious to know your thoughts, Anna. We're reading about virtual care a lot. Do you think it really is growing? And if you think it is actually growing, why do you think that is?
Yeah, we really have seen leaps and bounds, a fairly massive shift in virtual care in the healthcare context. If we think back just in 2018, only 3% of Canadians had used an online video consult before, and only 6% had emailed or messaged with their regular physician. Jump a couple of years to 2020, 34% had visited their family physician or regular place of care virtually. And interestingly, over 70% who used virtual care said they were satisfied and they thought it had saved them money. And the vast majority who were polled wanted to be able to use virtual care as an option. So we know it's expanded a lot. One of the key reasons for this is the funding has changed dramatically. So for the vast majority of provinces and healthcare sectors within Canada generally, there was no funding for physicians providing telephone advice, and in many cases, with some carved out exceptions, providing video advice. With COVID, that shifted dramatically, and it does vary from sector within Canada, but the vast majority of provinces and territories now have temporary or permanent codes in place to provide payment. And with payment in place, we've seen that dramatic shift. So we know that there's been a massive change, and some people say a huge step forward, others question it, but what do you see as the benefits of virtual care?
So it's interesting. I think about this in a couple of different ways. I think the one is from a patient perspective. I think a lot of patients find it convenient. They find it quicker. They're getting more access to health professionals, including specialists. We know that sometimes access to specialists can be slow in Canada. Some patients find virtual access to be quicker. And they feel like there are more options for treatment. We are seeing some interesting literature now on how in remote areas there are fewer gaps in access to care because you can access care virtually even if you live sort of in the remote Queen Charlotte Islands, as an example. I think at another level, there are benefits to healthcare providers. They feel like there are fewer unnecessary visits to the ER or the office going on. And, you know, generally with a virtual care platform, all of the health records are centralized in one location, which makes things much easier for providers. I think the third piece, which is maybe a bit new in the Canadian context and really interesting to think about, is there are virtual care platforms that market themselves to employers. They're B2B services. And they present themselves as the way employers can enhance their own employees' access to healthcare and improve their overall employee health and wellness. This has been talked about a lot in the States, I think is new in Canada. And I think that might be one of the things to really pay attention to if virtual care continues to take off in Canada. And so, it's interesting because there, as you noted, there's so many empirics about how people are excited by virtual healthcare. What do you think are some of the challenges posed by virtual healthcare?
Yeah, it's a good question, and I think there are still some challenges. Although we have moved forward a great deal, there are still some challenges in that we have provincial licensing issues and funding issues. So there are still some challenges in terms of physicians practicing cross province, and there's the limits of the technology itself. Clearly. Video and phone and the other options can only do so much. So there's limits on nonverbal feedback. There can be limits in terms of other symptoms that can be recognized when you're in person beyond the nonverbal feedback. Language barriers can clearly be exacerbated. And of course, not everyone has equal access to technology, as we well know from the past year. And so picking up on what you raised earlier, Ira, with the B2B services, some on policy-wise, certainly some commentators are suggesting that the rapid growth of private platforms for virtual care are creating a two-tier system, while others, as you pointed out, including in rural centers, believe they're maybe getting better access. So there's a back and forth on that. Clearly, though, and the colleges have set this out, there's the standards of care are the same. And to that end, the healthcare providers providing care over virtual care need to decide, can I give appropriate care virtually, or is it something that has to be in person? There was a recent decision from Quebec where a physician was suspended for 3 months after doing text messaging care with a young patient who ultimately died. And the college said it was very clear that those interactions required an in-person assessment. And I know we're short on time, so I'm going to turn it back over to you, Ira, in terms of challenges and ask you, because I know this is your particular area of expertise, what about privacy issues and virtual care, and are there any best practices you can recommend?
Sure. Well, I'm just going to make 2 points in the interest of time. The one is, in the same way that virtual care providers have to meet the same standard of care when providing care virtually, by law, you have to meet the same obligations with respect to health information privacy, even if you're operating on a virtual platform. And, you know, we encourage people to think about things like your platform, your devices, making sure no one's recording. There are a lot of very practical steps that people can take to minimize privacy risk. But I'm going to stop there in the interest of time. Thank you, Anna, and back over to you, Graham. Thanks.
Well, thank you, Ira. Thank you, Anna, both for that very interesting presentation. We are just slightly over time. We're about 5 minutes behind, so I just ask our final 2 presenters or presentations just to note that. And what I'll also indicate is that we'll provide answers in a separate question and answer document that will circulate to all registrants following the presentations today. So healthcare providers have worked in a remarkable, challenging environment for the past year, and traditional practices have been significantly disrupted by the pandemic. Wendy Whalen and Megan Payne from the Health Law Group will talk about the emerging trends in medical malpractice litigation connected to COVID-19 and the potential impact of immunity legislation on these types of claims. Wendy, Megan, over to you.
Thank you, Graham, and good afternoon, everyone. Thank you for joining us. So Megan and I are going to cover 3 topics very briefly: the immunity legislation, potential claims which may arise, and the impact of COVID on current medical malpractice litigation. And I'll turn it over to Megan to discuss immunity legislation.
Thanks very much, Wendy, and welcome everyone this afternoon. Jurisdictions across the country have passed various immunity legislation related to COVID-19 infections. I'll focus primarily on Ontario, but we'll mention the other provinces as well. In terms of Ontario, the immunity legislation that's been passed is called the Supporting Ontario Recovery Act, or SORA. Some folks may know it as Bill 218. And it came into effect November 20th, 2020. The immunity legislation provides immunity for any person, which the Act also defines to include a corporation. And it indicates that there's no cause of action or no claim against any person or corporation as a direct or indirect result of an individual being or potentially being infected with or exposed to COVID-19 on or after March 17th, 2020, so that's that state of emergency date that Barb mentioned earlier, as a direct or indirect result of an act or omission. And in order for that immunity to apply, there are 2 criteria that have to be met in the Ontario legislation. The first is that the person or corporation has to have acted or made a good faith effort to act in accordance with the public health guidance related to COVID-19 in effect at the time, as well as any federal, provincial, or municipal law related to COVID-19. So that's the first criteria. The second criteria is that the act or omission cannot constitute gross negligence, and I'll make a few comments on that in just a moment. In terms of other provinces that have either passed immunity legislation or immunity legislation are in the works, those include BC, Alberta, Saskatchewan, New Brunswick, as well as Nova Scotia. And the immunity legislation applies to different individuals depending on the different province and what the bill looks like. But interestingly, all of the legislation that's either been passed or is in the works carves out this exception for gross negligence. And effectively, that means that if an act or omission constitutes gross negligence, the immunity legislation doesn't apply. And it's slightly problematic and slightly challenging in the sense that, at least in the Ontario legislation, gross negligence is not a defined term. And in the context of medical malpractice negligence in Ontario, gross negligence is not something that's been considered in that context. So notwithstanding the fact that we have this immunity legislation, how the courts will define this gross negligence exception will be interesting, and certainly something that we'll have to keep an eye on as cases move forward in the system and as individuals attempt to use this immunity legislation to see how gross negligence is defined. So with that, Wendy, I'll hand it over to you. Wendy, I think you're muted.
Yes, sorry about that. Thanks very much. So we're still very much in early days of medical malpractice claims that may arise from the pandemic. And some of them, we may see them later, in part due to the suspension of the limitation periods last year. But generally speaking, it could be possible to see the following types of claims arise. The first, delayed diagnoses cases, people not attending for routine screening, or not seeking care, and even with symptoms for fear of acquiring COVID infection. We sort of see that this category may be less likely given the remarkable ability of the healthcare system to respond by providing virtual care appointments and whatnot that Anna and Ira talked about. We would then have the category of delayed treatment cases, and these would arise from canceling or delayed surgeries as a result of the impact of COVID-19 and various provincial orders and directives, particularly a concern over cancer, as most of us have read about it and have read and seen in the media. And then obviously we would have claims related to patient deaths as a result of acquiring COVID while in hospital, in residential care, in the community. And of course, when these claims do arise, they will engage various competing issues, such as whether any immunity legislation applies, public health measures necessary at the time to contain the infection, and the availability of public health care resources. And frankly, we may see more coming out of the second and third waves than we have in the first, due to, in part, in the first wave, a lot of things were unknown at that time, particularly around appropriate infection and control measures. And back over to Megan briefly to just talk about the impact on current litigation.
Yeah, so I think, it's important to recognize that across the country, COVID-19 has had a significant impact on, how cases are run, as well as the availability of judicial resources. So across the country, there have been various shutdowns of courts at various periods of time, as well as various suspensions of limitation periods or the time that you have to bring an action in. And while certainly some matters have proceeded virtually, there has also been a significant adjournment and delay of matters in order to protect the public health and protect the public health of those individuals working in the courts. We have received direction, at least in Ontario, that as things sort of open up more again, priority will be given to family law and criminal law matters, which are using the same resources as civil litigation. And so it's anticipated that unfortunately will likely lead to some additional delays in terms of trial times and motion availability in the context of civil litigation. That being said, and we want to end on a bit of a positive note, I think COVID-19 has also presented a tremendous opportunity for the justice system and for lawyers to change the way they practice law and really improve the accessibility of law. So we see, more cases being available online that people can watch, which leads to a transparency in the justice system. People can actually see how it's run. It's not all sort of law and order. People have also really adapted well to virtual hearings and virtual motions and virtual discoveries, and that presents a real opportunity moving forward when it comes to witnesses that are not in the jurisdiction and other scheduling difficulties that hopefully, we will see move forward in things as it opens back up. And I think finally we just say as well, judges have taken a very active role in trying to streamline cases and try to resolve them as quickly as possible to limit the strain on the judicial resources. And again, we see that as a really positive development. So thanks everybody for joining us this morning and this afternoon, and we'll turn it back over to Graham.
Great. Thank you, Megan. Thank you, Wendy. We tend to think of crisis as a relatively short-term, time-limited event. The last year and more has taught us how to support our people through a long-term, evolving crisis. Our final presenters today, Rebecca Bush from our Insurance and Tort Law Group and Kate Crawford from our Health Law Group, will talk to us about crisis management best practices in the short and long term. And over to you two.
Thank you, Graham. Good afternoon, everyone. Thank you again for joining us. And we are cognizant of the time, so we'll get through this as quickly as we can. As Graham mentioned, while traditionally we think of crisis management very much with reference to the acute or all hands on deck phase, which is often followed by internal review and lessons learned, the COVID experience over the past year has certainly taught us how to manage an ongoing crisis and what it looks like to move from that acute phase to long-term crisis management. While I'm sure that everyone attending today has had the opportunity to engage in ongoing crisis management in some form or another over the last year or so, Kate and I will briefly review what organizations can and should do to respond quickly and effectively to a crisis, and how to place systems that allow for continued management and often, as we saw this year, continuous pivots as a crisis evolves. While every crisis will be organization specific, there is no one-size-fits-all approach. There are general principles, however, and plans that organizations need to consider and put in place no matter what the industry or sector. I'm going to turn it over to Kate to talk about pre-crisis planning.
Thanks, Rebecca. We have the benefit today of being able to anticipate that crises will come down the pipes, and we've all seen that over the course of this year. So strong organizations prepare for the potential for a crisis and do it in a way that sets themselves up for success if and when a crisis occurs. First thing is the creation of an infrastructure for a crisis response team. So what an organization can and should do is identify what team members will be a part of your crisis response team in the event of a crisis. Now, obviously, team membership will change depending on the nature of the crisis and what parts of your organization are involved. But generally speaking, the table stakes for your crisis team will include members of your senior management, members of your operations team, your communications team, and risk management. And so having at least this basic infrastructure set up helps you have a team in place to move quickly if something happens or when something happens. These strong prepared organizations such as yours can also test your level of readiness with crisis drills akin to code mock-ups you run in a hospital setting, for example. So mock crisis drills can be as simple as an hour once a quarter or once every 6 months, where the team assembles, tests the infrastructure, and identifies any other traps or gaps in your team and in your plan based on scenarios that you can create for yourselves. An organization can also and should also scan for specific threats to your organization and adjust your plans to be more ready to respond. The drills we just spoke about just are an excellent opportunity to identify specific threats to your organization and be ready to respond to those that you have identified. It's also really important for an organization to really map out your operations and know what your critical assets and critical operations are in order to be able to at least keep the most basic function running, the lights on and the lines running in the early days of a crisis. And planning ahead will really help you identify what those key functions are and what base level infrastructure you need to keep those going if a crisis hits the organization. And finally, in the pre-crisis stage, it's really helpful to identify or pre-identify and develop relationships or retainers with outside sources that may help you in a crisis. So when I'm talking about this, I'm talking about things like PR consulting firms, legal support, investigation firms, staffing support, for example, and really identifying those resources ahead of a crisis and making sure that they're familiar with your crisis plans and aligned with your organization will set you up for as much success as you can reasonably hope for in a crisis setting. So now back over to you, Rebecca, and Rebecca's going to talk about the acute all hands on deck stage, which everyone knows all too well in today's world.
Thanks, Kate. This is also known as the official stomach lurch and panic phase. We've all had that moment where the floor has fallen out beneath us, whether it be personally or professionally or with our organization. While by its very definition, crisis means that there are many elements outside of an organization's control. There are aspects that can be controlled, and this is the key to getting through the acute phase of the crisis. Let go of what cannot be changed and focus on what can. So key points to maintaining this control are immediately engage your crisis team. Certainly, Kate took you through who should be a part of that. The key, though, with having a crisis team is ongoing communication and understanding. Make sure that everyone is aware of their individual roles and, more importantly, understands the agreed upon approach and response. No one should be operating in a vacuum. Often we see as lawyers, this is kind of in the stage of an organization where things may start to fall apart if they're not communicating and the right hand doesn't know what the left is doing. If warranted, strive for a reliable and fast-moving internal investigation. Use protocol to support regular, clear communication between investigators, the crisis team, and any other decision makers. Require interim reporting of investigation results, and the organization can then decide what changes, if any, also known as pivoting, need to be made in order to sort of weather the storm, so to speak. Certainly, we all know this in our roles that in a crisis, the media, the public, and key stakeholders will judge the organization based on its every action and every word. If litigation follows, an organization's actions and communications may be evidence. So organizations need to be controlled, consistent, and methodical in their response to crisis. This can be achieved by employing strong crisis leadership and teamwork. While Kate listed off all the important players in a crisis team, the one thing that we would want to emphasize is limiting the size of your crisis teams. Too many cooks make communication and control difficult, and as I said before, from a legal perspective, this is often where risk and crisis management arises. Employ protocol for all broader internal and external communications. Maintain confidentiality of deliberations, structure communications to support a legal privilege claim where possible, ensure that all documentation, electronic or otherwise, that could have any bearing on the issue is identified and, most importantly, preserved. No crisis team should expect perfection. We all know that in weathering the last 15 months, but fostering control will certainly minimize missteps and allow the organization to display strength. And I'm going to let Kate finish off with our long-term view of crisis management. Thank you.
Thanks, Rebecca. And as we've all learned over the last year or year and a half at this point, what we thought may have been a short-term crisis can sometimes evolve into what feels like a very, very long-term crisis or death by 1,000 cuts. When the crisis continues, a lot of the acute steps the organization has to take have to be changed or evolved to allow your business to continue or maximize operations while the organization continues to manage the crisis. So it becomes more of an effort to sustain both operations and responsible crisis management over a longer term period of time. So Rebecca just made reference to documents, and this is one that we've really observed through COVID is as the crisis continues, both individual and organizational capacity to manage just the volume of documents being produced and how they're retained really wanes. So ensuring that your organization has an established system and great support around document creation and preservation will really help you out in the long run, both from a communications perspective and retrospectively if you ever have to go back and look at things again. So consider a document lead and whether there's someone in your organization who could have a role in ensuring that they have a bird's eye view, at least, on everything that's being created and where it's stored. One thing we've all talked about this year a ton, of course, is both employee and leadership capacity and burnout. We have all learned this year that crisis teams and those whose day-to-day work are impacted by a crisis are at huge risk of burnout as the crisis continues. So as I'm sure we've all continued to do, we have to keep ensuring regular touch points and check-ins on capacity, burnout, and mental health. Mid-organization or mid-crisis organizational change is something we've really seen. You may receive feedback during the course of a crisis from investigators, employees, from leadership, or clients about potential changes that can be made organizationally to mitigate either the cause or the effects of a crisis. Organizations really have to be mindful in achieving the right balance between reacting to these new pieces of information or new learnings in a responsive but not knee-jerk manner. So organizations ought to really carefully consider the implications of organizational change midstream. And think about it from, in your organization's ability to function, the effect of any potential systems changes on productivity, functionality, and then, the lawyers and us have to say that at the end of the day, also, the last thing we want you to think about is the impact of those midstream changes on litigation. But of course, your ability to function as an organization comes before that. Last point is when a crisis starts and continues, we should anticipate that there will at some point be a look back or a review of organizational response to the crisis. So with every decision that you make, consider the implications on the various stakeholders, being the public, your clients, your employees, and do your best to ensure that the responses to any changes would withstand retrospective scrutiny. As the crisis evolves, you'll likely know more through the evolution than you did at the beginning. So test earlier decisions against your current knowledge and don't be afraid to pivot as appropriate. So that's a 10,000 foot view, Graham, from Rebecca and I, and sorry for taking up so much time. We're really grateful for everyone having signed on today.
Well, thank you very much, Kate and Rebecca, for that practical information and advice on how best to support everyone's people through crises like the one we're in the midst of. And all that concludes our presentation today, which I truly hope has been relevant and interesting. I would like to thank all of you for attending today, and I'd like to thank all of our speakers, obviously, for their very good presentations. We have recorded this seminar, and we will circulate a copy of the recording to everyone who has joined us today. And as I mentioned before, we will respond in detail to the various questions we received, and we'll circulate our responses to the questions in a document to all. Enjoy the balance of your day. Oh, and finally, this seminar does qualify for CPD credits in both Ontario and British Columbia. Thank you very much.